Rules Committee to come to order, and thank you very much. I apologize in this case, the chairman's late. I was across the street at the gentleman, Sam Johnson's big show. We were putting up Sam's portrait today, and the gentleman, Mr. Johnson, as we all know, has served in this body since 1991, and there was a distinguished crowd. And we waited until his beautiful portrait was unveiled, and it was really a very nice affair on behalf of the gentleman from my colleague from the 3rd District of Texas, Sam Johnson. So I apologize, my fault. Today we are gathered together with an opportunity to address, in essence, 3 bills that will be before the committee. The first is H.R. 2851, Stop the Importation and Trafficking of Synthetic Analogs Act of 2017. This bill that we have before us today is an important bill because it speaks very clearly about some of the problems that are facing our nation at our borders based upon an unprecedented amount of drugs which not only continue to come in this country, but also the ability that we have to understand what those drugs are and to properly look at them. Also, H.R. 5735, Transitional Housing for Recovery and Viable Environmental Demonstrations Program Act, which will be out of the Committee on Financial Services. And lastly, H.R. 5788, Securing the International Mail Against Opioids Act of 2018. The gentleman from Ways and Means Committee, Mr. Brady, Chairman Brady, will be here for that. So before we go any further and acknowledge our 2 distinguished guests that we have, I want to move directly to the distinguished gentleman from Massachusetts for any opening statement. Gentleman,
thank you, Mr. Chairman. And I just want to say I'm happy to see that the Republican leadership is finally taking some steps to address the opiate crisis devastating our nation. We have 3 bills before us, a couple of good ideas, one not so good idea. But unfortunately, none of the bills we're considering provide a long-term funding solution to address the epidemic. And we need to make sure that these good ideas are funded. It's also ironic that this week and next week the House is focused on the opioid crisis while the Republican administration is continuing to wage war on Americans' access to health care. Last week, the Trump administration urged the courts to strike down the Affordable Care Act's protections for individuals with pre-existing conditions. Perhaps my colleagues are unaware of this, but substance use disorder is a pre-existing condition. So on one hand, here we are working around the edges to fight the opiate epidemic without putting any long-term funding behind it, while at the same time, Republicans are attacking health care for individuals with opiate addiction. These people are in desperate need of treatment, but this administration is actively working to undermine their health care. This is a devastating blow to Americans suffering from addiction. There is a full-blown epidemic of opiate addiction in our country. Our house is on fire, and while we're over here throwing a few buckets of water on it, the Republican administration is fanning the flames. So I congratulate the majority on finally turning their attention towards the opiate crisis, but without protections for pre-existing conditions, many people with substance use disorders will be unable to afford treatment, and this epidemic will continue to ravage our communities, and lives will be lost. And so with that, I will yield back my time.
I thank the gentleman not only for his attention to the nature of the important epidemic that faces us, but also for his generous opportunity to understand that Congress must address the issue. I know the gentleman seemingly is aware of a huge meeting that took place finally as a result of legislation that we passed in late 2016 directing Health and Human Services. And last week, Dr. Brett Giroir and Dr. Vanila Singh from HHS, the what's called ASH, Assistant Secretary of Health, and the Chief Medical Officer from HHS, participated and led a big effort that took place at HHS where they had some 96 experts from across the country who have been vetted and dealing with from various angles this opioid crisis that faces America. And it's easy to say that we're behind. It's also easy to say that we're trying to catch up with sound medical evidence, advice, and consent, while at the same time we recognize, and I would draw to the attention, I'd like to place within the record an article, May 31st, U.S. News and World Report, more drivers killed under the influence of drugs than alcohol in the United States of America. And I start with reading some 22.3% of fatally injured motorists who were treated for drugs tested positive for marijuana in 2016. The devastation that is taking place on our roads and in our homes, in our universities, as well as the problems that we have with the opioids are taking this country to an unprecedented level to where we need to address the addiction problem that we have. And I appreciate the gentleman bringing this up, his insistence that we continue moving forward, not only with ideas, but making sure that Health and Human Services, National Institute of Health, and the FDA are involved in those processes to make sure that what we properly do is come up with a science-based answer, not just one that is based upon doing the right thing. I would also say to you that the involvement of the Judiciary Committee by the distinguished gentleman, Mr. Goodlatte from Virginia, has engaged the administration, I think, very positively, all the way from the Department of Justice across the board and the White House, and I want to thank him for his service to this important issue, not only the laws, but also addiction from a medical perspective. I've talked to Dr. Phil Rowe a number of times about the VA. We're attempting from what I would say the Article I perspective of the United States House of Representatives to make sure that we are leading edge in talking about these ideas, and I want to thank the gentleman for keeping us on point with that notion that he brings up. We're honored to have our first panel, the distinguished young chairman from Virginia, Chairman Goodlatte, the gentlewoman from Texas, Sheila Jackson Lee, and the distinguished gentleman, Morgan Griffith from Virginia, who shadows the Rules Committee about as much as any non-member. We're delighted to have you, certainly Mr. Griffin, delighted that you're here. Without objection, anything you brought in writing will be into the record. I will encourage you, when you finish, to please let me make sure you leave that for our awesome stenographer. The distinguished chairman is now recognized.
Well, Chairman Sessions and Ranking Member McGovern and members of the committee, thank you for the opportunity to appear before you today as you consider the rules for H.R. 2851, the Stop the Importation and Trafficking of Synthetic Analogs Act, or SITSA. This bill is designed to improve and modernize certain sections of federal drug law. It will get deadly synthetic drugs out of the hands of drug traffickers and into the right hands of qualified researchers. Kristen Holman adored her little brother, Garrett. She cherished his warm heart and his bigger-than-life personality. She loved her brother unconditionally, as did her mother and father, Bobby and Don. Unfortunately, on February 9th, 2017, at the age of 20, Garrett lost his life to a synthetic drug that was mailed straight to him from China. My district lost a promising young man. Don and Bobby lost their son, and Kristen lost her little brother and only sibling. Sadly, tens of thousands of families across the nation have lost their loved ones to the opioid crisis. According to the Centers for Disease Control, drug overdoses killed over 64,000 Americans in 2016, a staggering increase of over 21% from 2015. Of those souls lost, over 20,000 deaths were caused by synthetic opioids, the same type of drug that took Garrett's life. Regrettably, the suffering shows no sign of slowing, as deaths from synthetic opioids have more than doubled from last year. Synthetic drugs can be more potent and deadly than the real thing. However, when law enforcement encounters a certain synthetic drug compound and takes steps under current federal law to bring the drug under lawful control, the manufacturers of these synthetics slightly alter the chemical structure of the drug to once again evade law enforcement. As a result, law enforcement is constantly one step behind the manufacturers. Left undeterred, manufacturers and distributors continue to flood the U.S. with deadly synthetic drugs. Seizures of illicit fentanyl by Customs and Border Protection increased 64,000% between 2013 and 2017. We must stop this flood of poison that is fueling an epidemic that has taken far too many lives. This bill ensures that manufacturers and distributors of deadly synthetic drugs cannot continue to evade law enforcement. SITSA modernizes the Controlled Substances Act by clarifying the regulation of synthetic analogs. First, CITSA amends the Controlled Substances Act to establish Schedule A new category for controlled substance analogs. Second, the Act establishes a streamlined mechanism by which synthetic analogs can be temporarily and/or permanently added to Schedule A, but only after a thorough analysis by the Attorney General and the Secretary of Health and Human Services. Altogether, CITSA will combat the flow of synthetic drugs that have taken both Garrett's life and the lives of 20,000 Americans over the last year. This bill was carefully crafted over the past 2 years with extensive coordination between law enforcement agencies from the Department of Justice and scientists and researchers at the Department of Health and Human Services. Together, this bill strikes a balance between giving law enforcement the ability to stop the flow of deadly synthetic drugs while allowing the research community to study these dangerous drugs, identify the root causes of addiction, and advance the latest cures for serious illnesses. These are principles that every member of Congress should enthusiastically support. I also understand that there has been substantial discussion about the issue of immediate suspension orders, or ISOs, in the context of this bill. I take that issue and the discussion very seriously. My staff is currently working with all interested parties, including the administration and members of the House and Senate, to resolve it. I understand that amendments which were filed to address this issue are likely non-germane. I agree with that assessment. The bill before this committee today is intended to address the growing prevalence of synthetic drugs. We will address the ISO issue separately and are currently working to achieve that goal. I'd like to thank Mr. Katko of New York for his work on this important legislation. And Mr. Chairman, I just want to add as a personal note, I know the Holman family. I know the terrible loss they've suffered, but I also learned from his sister and his father that he started getting these drugs, these synthetic drugs, mailed to him directly from China because he was told that they could come to him directly, that they would not show up on a drug test at his workplace of employment, and that they were legal. We've got to change that and save a lot of lives. Thank you, Mr. Chairman.
Glad that you're here, Mr. Goodlatte, and I appreciate your testimony. Distinguished gentlewoman from Texas.
Mr. Chairman, if I might
Yes,
add, the Speaker has commanded me to appear in his office at 5:30 for another meeting, and I've asked Mr. Marino to step in my place.
If you hold on just one moment, please, sir. I always try and accommodate as best as possible, as you know, any member that comes up here. And in fact, the gentleman does need to leave. Is there anyone that has a specific question for the distinguished chairman? Is there any question that's for the distinguished chairman?
Thank you, Mr. Chairman.
I'm sorry, guys.
I would just add the immediate suspension order there's a critical need to address this, and if we're not able to do so today, I want to put my thoughts behind that because we need to make some changes.
I agree, and we'll
Yield back.
continue to work on it.
Thank you very much. Is there any other member of the committee that would seek to engage gentlemen? Mr. Chairman, I want to thank you. Please know that I am aware that this issue that the gentleman just spoke about, we're attempting to move forward, that took place from a meeting that was held in my office today with your members of your staff, and we're moving forward on that. I want to thank you. If you'll please make sure that anything you brought in writing for us, Mr. Stogfer, will still be available for her, even despite your leaving at this time. And the committee would welcome the gentleman, distinguished gentleman from Pennsylvania 10, the gentleman, Mr. Moreno. If you could please come and take the gentleman's place. Thank you very much. Ms. Jackson-Lee, we're delighted that you're here. Gentleman is recognized.
Let me thank the Rules Committee and the Chairman and the Ranking Member for allowing us to be here today. And let me publicly offer my concern and sympathy for families who have suffered in the face of the rise of synthetic drugs, and as well recognize that this is Opioid Use Week. I hope it is Opioid Opposition to Opioid Use Week, and there are a number of bills on the floor of the House. And I hope that my colleagues on the Rules Committee take my comments in the constructive way that they are being offered, and I really would hope that some of my amendments will come in only to make the bill better. No one could sit in this chair and serve on the Criminal Justice Committee for the years that I have served and in any way want to diminish the devastation of drugs and as well the importance of getting it right. we in the Judiciary Committee, and particularly in the Criminal Justice Committee, have been facing two sets of pitchers, if you will, and that's in the baseball analogy. We've got two pitchers on the mound. One of them is to respond to the evangelical community and the conservative community and the progressive community on mandatory minimums and mass incarceration. And then the other side of it is to make sure that the real bad guys get what they deserve. I think that this bill, as I hope my colleagues will listen, needs a number of additions to ensure that it does not happen. And in terms of that we pick one over the other. This bill has some possibilities of doing so. H.R. 2851 would establish new federal crimes related to the misuse of controlled substances identified in the bill under Schedule A. I'm acutely concerned about the dangers presented by drugs like fentanyl. In fact, in one of our bills that we hope we'll see on the floor of the House, sentencing reduction, the enhanced fentanyl was in there, and it drew some opposition. But the overall bill of sentencing reduction, which I still advocate for, hope to see on the floor, was a valuable bill to approach the concern of mandatory minimums. So I'm familiar with any number of synthetic drugs, but and its synthetic analogs have contributed to a disrupting number of overdose deaths, even in my home district of Houston. The bill is well intended, but it has several issues that need to be corrected. First, it amends the sentencing guidelines without the input of the U.S. Sentencing Commission. And frankly, the Sentencing Commission has expressed to us a concern because the law has designated the Sentencing Commission to make assessments about the sentencing and as well the dangers of drugs. And this Sentencing Commission is currently undergoing a robust examination of this complex topic of synthetic drugs and penalties. Since this legislation was introduced, the Sentencing Commission approved a multi-part synthetic drug amendment in April 2018, which included extensive public comment, expert testimony, and a multi-year data analysis. The Commission's recent amendment creates a class-based approach for synthetic drugs, establishes a new drug ratios, and a new guideline penalty for fentanyl analogs. That is why I offer Amendment number 4, to strike Section 9 because it's unnecessary, overly broad, and duplicate of the Commission's existing actions. Congress delegated the authority of the Commission to amend the federal sentencing guidelines 2 decades ago in order to ensure fair, data-driven outcomes in federal sentencing. This provision departs from that process. So the Sentencing Commission has on the ground, if you will, my amendment would allow the Sentencing Commission to go forward and to utilize their analysis and their analysis of the drugs and as well their sentencing suggestions. Second, this bill criminalizes those in possession of these drugs, many of whom are in dire need of our support and medical care. And I agree with our ranking member. I'm disappointed of where we are as it relates to pre-existing condition, because the way we passed a lot of the opioid bills last year was dealing upon the Affordable Care Act and the fact that we moved to the idea of not criminalizing drug users, but that it's a sickness and an illness, and we wanted to get them treatment, particularly under the structure of the Affordable Care Act. These are people who battle addiction, substance abuse, and mental illness. We recognize this as an alarming epidemic and the need for medical treatment, which is why we appropriated a large amount of money towards the opioid crisis, or attempted to do so in our recent omnibus bill, which passed in the House. We need more money, and obviously I agree with my ranking member. But that is why I'm offering Amendment number 5 to avoid mass incarceration over criminalization of the user. Amendment number 5, which will not criminalize individuals that are mere users and lack the necessary mens rea requirement as prescribed in 21 U.S.C. Section 841, which this bill amends. Let me be very clear. There are many of our users who are buying them on the streets, and they don't know it's laced with any synthetic. There's no label on these particular drugs. And so, buyer beware. These are addicted persons, and you are now putting the the user in the same category of getting the same sentencing under this legislation as others. Third, although we know that synthetic analogs are often manufactured outside the country, namely China, which the chairman has said, where the substances are mixed with heroin and where users and sellers may lack knowledge of the presence of these substances, this bill heightens the penalties nonetheless. That is why I offer Amendment Number 9, which ensures that the penalties for Schedule A controlled substance analogs may not be ordered to run consecutively with the penalty for the first controlled substance. In June 2016, the head of the DEA, Chuck Rosenberg, testified before the Senate Judiciary Committee that illicit fentanyl derivatives and their immediate precursors are often produced in China. By the time the drugs enter the United States where they were sold, such as the young man tragically who lost his life getting them online, he said buyers and sellers are often unaware of the composition and potency of the drugs. And lastly, this bill imposes mandatory minimums, which we fought against mightily. They do it in the sentencing component, so that in the supervisory component, so that you have mandatory minimum under the supervisory component. So I've offered amendment number 16, which will exclude the mandatory minimum provision, still allowing the persons to be under supervision, but the inclusion of a new mandatory minimum sentence is particularly egregious because these inflexible one-sentence size sentencing laws undermine justice in our country. From the Judicial Conference of the United States, we have concerns about Section 4 of H.R. 2851, which would impose a mandatory minimum term of supervised release of 2 or 4 years, depending on whether the offender has a prior conviction for a felony drug offense. They go on to say mandatory minimum sentences, including mandatory minimum terms of supervised release, waste valuable taxpayer dollars, create injustice in sentencing, undermine guideline sentencing, and ultimately foster a lack of confidence in the criminal justice system. These are not my words. These are the words, if you will, of the individuals that are seeing these cases every day. I was also prepared to offer an amendment to address the lack of collaboration with the scientific community, but I want to applaud Mr. Griffin and Mr. Raskin. I hope he's here for that amendment. They will be offering an amendment to address the importance of the scientific community in this process. I'm delighted to be a co-sponsor of that amendment and certainly hope it will be made in order. I'd ask my colleagues to read carefully my amendments, particularly the one about mens rea dealing with the user, and particularly looking at the issue dealing with the Sentencing Commission and its work that has already been done. I look forward to either working on some modification thereof as this bill goes to the floor. It doesn't go until Friday. But I think if we have a Sentencing Commission that has done extensive work, that we really need to respect that process, and it will complement the bill offered by Mr. Katko. So I would hope that we would be able to work with the Rules Committee, work with the sponsors of the bill, but I do hope that in addition to Mr. Raskin's and Mr. Griffin's amendment, which I support, that you will seriously and carefully look at the amendments that I have to offer that can only make this what needs to be bipartisan bill out of judiciary bipartisan, because it will reflect on some of the issues that the Judicial Conference has offered. I ask unanimous consent to place this letter in the record. And I likewise would like to place Freedom Works' statement into the record, which has as part of it, the bill over-criminalizes drug offenses by broadly expanding penalties. I believe we can find a compromise on these synthetic analogs by ensuring that some of the provisions that I have offered are seriously considered and made in order under this structured rule. I'd like an open rule, but I would appreciate if they could be made in order under this structured rule. Mr. Sessions, I will say to you that all of us are in pain when we see our neighbors, friends, our relatives, our community under the siege of drugs of any kind. What we need to do is get the addicted help, and the criminals we need to address. Many of these people under this bill will be those who need help. And with that, I...
Ms. Jackson, thank you very much. As the gentleman knows, she's been treated, in my opinion, well by her commitment to the Rules Committee, not only with amendments, at least over the last 6 years, but I believe all 20 that I have been on this committee, and she has been very vigorous in her enunciation and support, and I would believe that your viewpoint will be taken into consideration most fairly, and I think the gentlewoman knows she's been treated that way over the years, and I hope that she said that with confidence. I took it that way, and I appreciate the gentlewoman's comments very much. Thank you very much. Mr. Griffith, welcome to the Rules Committee. You spend a lot of time up here. We try and learn from you, but more importantly, we're delighted to hear from you. And when the gentleman has time before the committee, we welcome that. Gentleman's recognized.
Well, I appreciate it, Mr. Chairman, and I would have to say that I do come up from time to time, but it is to learn and not to teach. On this occasion, I do have an amendment. It's Amendment Number 1 to the SITSA bill. This amendment incorporates an interagency agreement transmitted to Congress by the Office of National Drug Control Policy, the United States Department of Health and Human Services, and the United States Department of Justice. It clarifies several issues when the Attorney General can temporarily and permanently schedule a drug or substance to the newly created Schedule A. It prevents the Attorney General from permanently scheduling a drug or substance if the Secretary of HHS determines that there is not sufficient potential for abuse. It also clarifies when research can be conducted with a Schedule A substance while a registration application is pending. If an applicant is registered to conduct research with a Schedule 1 or 2 substance, they can continue to do research that they may be pursuing with a Schedule A substance while their application is being processed. If an applicant is registered to conduct research with a Schedule 3, 4, or 5 substance, they can continue to conduct research with a Schedule A substance while their application is pending, so long as the component that gave rise to the Schedule A determination is in the same or a less restricted schedule. This is important to research. This amendment will help ensure that research is not impeded or stunted because of a change in the schedule of a particular substance. While we all want to get dangerous substances off the streets, history has taught us that when a substance is scheduled, many research options are taken off the table or made prohibitively complicated. Sometimes derivatives of dangerous substances can provide cures and treatments for deadly diseases or chronic conditions, and we don't want to hamstring our researchers who are equipped to discover potential positive uses. One that comes to mind for me almost immediately is the fact that one of these analogs may actually be a less addictive form. It may need to be controlled, but if researchers are looking at it as a less addictive form of pain relief, we would hate to stop that research while we sorted it out. This allows the research to continue while their application is pending in front of the appropriate authorities. And so that's what the amendment does. I think it's a good amendment. I appreciate the kind words of the gentlewoman, Ms. Jackson Lee, in support of that as well.
Thank you very much. Mr. Moreno, you're now sitting in for the distinguished young chairman of the Judiciary Committee, Mr. Goodlatte. Does the gentleman wish to make any comments?
I do.
Gentleman's recognized.
The issue concerning mandatory sentencing for individuals who are using, as my colleague from Texas addressed, is taken care of in the legislation. In the Rules Committee copy on page 8, lines 22 through 25, section B, a person shall not be subject to a criminal or civil penalty under this title or under any other federal law solely for the possession of a Schedule A controlled substance. And I do want to explain something concerning, and then use the example of fentanyl. The problem that we're running into, the Chinese are very adept, and let me qualify first. I had enough chemistry in college to make me dangerous. But the Chinese are very adept to taking a molecule from a synthetic drug and changing the structure, if you will. Picture for a moment a molecule and the spikes that come off that connect it to other molecules. The Chinese are very good to taking an atom, a single atom from that molecule, and either pulling it out or changing the structure of it or connecting it to another type of molecule. This process, which is very complicated, technically does remove that drug then from being a controlled substance. And wish the Chinese would adapt to other more positive parts of chemistry than changing the drug that they are shipping out around the world, more so than anyone else, fentanyl, and just changing an atom on that, saying that it's not a controlled substance. And that I yield back.
Thank you very much. As we look at the circumstance of enforcement and identification by maybe the post office now, even though not necessarily under this bill, but the post office or a carrier. The law enforcement components, whether they be DEA, another DOJ component, or health, Homeland Security, as they look at these shipments that are coming in, are they able to see them or sniff them, or does it take actual, how do they go about this enforcement mechanism, and where do they do that? Do they do that in Miami, when essentially when it comes in, as I understand it, from the bulk shipments, or are they finding this en route?
We do have a little bit of an expert here, Dr. Burgess, to answer that question. I know there's no way of the dog picking this up at
Okay.
this point. And tell me if I'm wrong, Doctor, if
Dr. Burgess, in fact, has been down a number of times on inspection as his committee assignment, where he came to this committee as a result of him being the subcommittee chairman for health. And so I will just talk with Mr. Burgess, Dr. Burgess, about that. But I do believe that our insistence that we catch these before they get here
from what
is
I'm
certainly
told,
easier.
it takes a chemical analysis because of the complicated structure of a molecule and the atoms within that molecule.
Okay.
Mr. Chairman, I'm happy to answer any questions, but I've been advised that I have a bill on the suspension calendar on the floor that they're holding for me to get down there.
Thank you very much, Ms. Griffith. Gentlemen, hold just a moment, please.
Yes,
Is there
sir.
anyone that has a specific question for the distinguished gentleman from Virginia?
I just say support making his amendment in order.
Thank you very much. You've got two fans up here, Morgan. It takes 9, but perhaps we can get there. Thank you, gentlemen, very much. Gentlemen would be excused. Thank you very much. Dr. Burgess?
Thank you, Mr. Chairman. And just on that issue, so there's no misunderstanding, I have made one trip with Dr.
I'm sorry,
Gottlieb
I knew it had been a trip, then I referred to it as multiple.
to the International Mail Facility at JFK Airport in New York. And it is startling, the amount of stuff that is coming in to
And it's
this
dangerous.
country. It's dangerous from so many different levels, but just to your specific question about the analysis, through appropriations done through this Congress, the Customs and Border Patrol are provided with handheld mass spectrometers that can differentiate between, say, a fentanyl analog and another compound called ketamine, which is sometimes imported in bulk. So there are methods that are available. The drug sniffing dogs have to be particularly careful because they can actually overdose because of the potency of this stuff. They can actually overdose just by virtue of their investigation. So they are trained to retract and sit down when they alert about a substance. It was really quite impressive the way they run up and down the conveyor belts. I guess my only question, Mr. Marino, this creation of this new scheduling method is designed to, just for a period of time, put one of these compounds into this Schedule A, and then they would be subsequently rescheduled, or is that assignment to Schedule A going to be a permanent assignment?
It is a temporary situation at this point. But let me make something else clear, and I'm sure my colleagues, most of them know about this. When it comes to any type of drug or any type of mandatory sentencing, regardless if it's fentanyl, cocaine, crack cocaine, marijuana, opioids, both at the state and the federal level, prosecutors have a great deal of deference in this. And I've done it myself, and I've seen it done numerous times in the courts. There are cases presented to the judge as to why not, and why there should be a mandatory sentencing. So there is an oversight to a certain degree, not only with the prosecutor, but with the court as well, when mitigating circumstances are present.
And just one other one other point, and I appreciate the comments that were made about funding levels. As you know, we're working through a number of bills this week and next week. The funding provided in the last Congress was at a level never previously appropriated, $1 billion in the Cures bill, and I believe there was an additional $4 billion in the recent omnibus bill. So the fact is that this Congress has provided unprecedented funding for this problem, and I think it's very clear that additional funding is going to be required in the future. And the fact that we've got a number of authorization bills on the floor over the next 2 weeks, I think is indicative of the commitment to that funding. And I'll yield back to the gentlelady.
Thank you. The gentleman yields back. Are there any further questions?
I just would say that, look, I think this bill's well-intentioned, but I have some serious problems with it. I hope that some of these amendments can be made in order. I agree with Ms. Jackson-Lee that when she refers to the U.S. Sentencing Commission, who's been working on ways to address the seriousness and complexities of synthetic drugs for several years, and I think that again, while it's well intentioned, I unless these amendments can be made in order, I'm not sure I can support it in its current form. I don't know. Ms. Jackson-Lee, you wanted to respond to something.
I did. In a concern for the time of the Rules Committee, I rushed through my words on Amendment 5, but I did point to the section, and the section that I referred to is on page 7, and it really goes to the collective body of individuals that are organizers, leaders, managers, supervisors, who are not necessarily proud citizens of the nation, but all it asks is for a mens rea standard, because when drugs are laced, if you're selling heroin, it's one charge. If you're selling laced with the synthetics, to be able to determine the knowledge of this individual of that. And so that goes to the point of the increased mandatory minimums and the sentencing of individuals who might have no knowledge of the contents of that, and so of the actual product that they're selling. To my colleague's point, yes, prosecutors have a lot of discretion, and I welcome that. Under General Sessions is requiring and is asked that the defendant, the person who is presently in the custody of the criminal justice system, that every single charge be placed against this person. The smart crime program or approach of former Attorney General Sessions is no more. And so you will be charged with everything. So I'm not sure, he sent a memo to the U.S. attorneys on that. I'm not sure where the discretion will come in place. But in order to address the question of mass incarceration, just simply have a mens rea for these people who are out on the street, just individual small-time dealers, as to their knowledge. It's not online from China, but these small-time guys, just make sure that there is a mens rea standard, which all of us would want to see. And that is, as I said, under Section 841.
I thank the gentlelady for clarifying that. And again, I'll just close by saying, I mean, as I said at the opening here, as we're attempting to try to deal with this opiate crisis from a number of different vantage points, it is ironic that the Trump administration, as we speak, is trying to strike down the Affordable Care Act's protections for individuals with pre-existing conditions. And again, substance use disorder is a pre-existing condition. I find all this really strange that this is all happening at once here. And again, with that, I yield back my time.
Gentleman yields back. Does the gentleman from Washington seek time?
Thank you, Madam Chairman. And I had to step out just for a minute, so maybe you've covered this, and just real to help me understand the problem and the solution here. I was thinking and putting it in terms that maybe as I didn't know what exactly an analog was, but if we change this to say something that we're maybe more familiar with, liquor. During the Prohibition, liquor was illegal, right? So if we make it under the terms that we're trying to fix here, say corn whiskey was illegal, but if I made whiskey out of rye, that wasn't. So that wouldn't be subject to prosecution. Is that kind of, is that a good analogy for what we're trying to fix here? That one drug is illegal, but if you change it just a little bit, it's not necessarily?
I don't, no disrespect intended, but I think the analogy's off to a certain extent.
Good.
Because of the fact that the chemical basis is alcohol.
Yes.
I don't know if you were here when I was explaining
I heard Mr.
a little
Goodlat's.
bit of the chemistry of this.
I did
And I
not.
prefaced that with, I've had enough chemistry in college to be dangerous. But picture, if you will, a molecular chain. The molecule with the spikes coming off could be connected to other molecules.
Sure.
Well, within that molecule, there are atoms. The Chinese have devised a way to, within that molecule, either remove or change how an atom is connected to another molecule that, in essence, would technically remove it from being a controlled substance. But still, it is still as deadly, it is still as dangerous, and we're talking about changing atoms in molecules as opposed to what ingredients you're using to create alcohol.
So it's no longer that general substance, it's something else.
Yeah, it's very complex.
Okay. Okay. Which is why we have to update a 40-year-old law that did not apply, or does not apply.
Correct, because it took years to get a drug scheduled as being an addictive drug.
Sure.
And this cuts that down to a couple of months temporarily.
Okay, well, that's helpful, I appreciate that. And again, apologize for missing your first
No,
explanation.
that's quite all right. If you saw the chemical makeup of it, you'd think, man, where'd this come from? It's
Okay.
a bunch of lines and molecules and a real big sheet of paper.
Okay, good. Well, thank you very much, and appreciate your bringing this important legislation before us today. Thank you, Madam Chair. I'll yield back my time.
Well, if I might respond to Mr. Newhouse.
Oh, absolutely.
If I might respond to as well. There is no dispute among those of us on judiciary on the new arena that we're in with the synthetic drugs. They are probably going to grow and expand just as heroin has made a return. But what we are saying is, I was very grateful that in the last opioid initiative on legislation, we actually passed a treatment bill. The point is that the idea is to recognize the danger, but also to recognize that there are persons who are small-time sellers, there are users, and the idea is putting them on Schedule A to make sure that we maintain the importance on some elements of the individuals for treatment, and that in this bill, we don't create a whole new farm team of people who will be under mandatory minimums, people who didn't know that the particular synthetic was in the drug, and so the amendments that I've offered is to respond to that. In addition, I'm not sure if you were in when I said the Sentencing Commission has done an extensive scientific analysis and issued its report on April 2018. Legislation indicates that you're almost overriding the Sentencing Commission, and I believe that they are appropriately designated to do this hard work. And Congress and the prosecutors and judges take the Sentencing Commission's work very seriously. They have been involved in this, and so I wanted to make sure that we're not duplicating their work or ignoring their work so that we get the bad guys, but that we don't create a whole new generation of incarcerated persons under mandatory minimums and build up on mass incarceration again, against what we are trying to do with all the people that we know are sick. We want to save lives, but we also know people are sick, and we don't want to wrap them up in the criminal justice system.
Thank you very much, Mr. Moreno.
I'd like to make another point here, just a common sense point. First of all, as I said, users, under the circumstances of just a user, will not be subjected to the mandatory. But who in the, I'm going to say, in the United States and even in the world, does not know what these drugs are doing to people? And I don't care if it's a small-time dealer or not. It's a dealer. And they don't have to read the newspapers, which they probably don't. They don't have to watch Fox or CNN, which they probably don't. But on the street, the message is out there how deadly these drugs are. And I'm sorry, I'm not going to be convinced that there's somebody out there who sells this stuff. It isn't aware of how dangerous and deadly it is. So that's why the mandatories are important, because it worked with the crack cocaine, it worked with the cocaine, and as I said, there is an element of discretion that's involved in this, and mitigating circumstances can be argued before the court.
Well,
Great, thank you very much. Does any other member of the panel seek time?
I do.
Mr. Hastings?
Thank you very much, Chair Lady. I appreciate it very much. Mr. Marino, where were you a prosecutor, in Pennsylvania?
I was in Pennsylvania, and
For
then
how long, sir?
an assistant for 2 years and a district attorney for a little over 10 years.
Right. I practiced law for 13 years.
And I was a
in
U.S. attorney.
I was in state courts for 2 years and federal courts for 9.5 years. One of the things that's distressing and disturbing, and I think history teaches us, that mandatory sentences have not reduced crime. Would you agree with just that statement? I just heard you say something that I think is different.
I do not agree with that statement.
You think mandatory sentences do reduce crime?
Yes. It does reduce the sale of certain drugs, because I've experienced it in my own county and my own state, and I've seen it in my district as the United States Attorney for the Middle District of Pennsylvania.
What was the racial makeup of the community that you said?
That's a long time ago. I don't know what any numbers are.
Well, during that same long period ago, what we learned over the course of time is that people of color were more subject to mandatory sentences
Well, let me
than
stop
others.
you right there, sir, because when I was a prosecutor, color had nothing to do with it.
Yeah, right.
I want to make that perfectly clear.
Yeah, I trust you, Mr. Marino.
Thank you.
I've seen lots of prosecutors in my lifetime.
And that's where I say, sir, that the judge has influence here. The judge can, I've gotten into
Not
a
on
couple of
mandatory minimums.
arguments with judges on mandatories and saying,
Hold on, judges don't have that much influence on the sentencing guidelines that require them to exercise mandatory, and not only in this arena, but in a whole lot of arenas.
but sir,
Listen here,
as a
man.
judge, as a judge, how a judge does have influence, maybe not directly, but indirectly on a prosecutor, which I had no problem with. There were times when judges have pulled me aside and said, Tom, I don't think the mandatory is right in this, and we had a discussion about it. Sometimes I agreed, sometimes I didn't. And I would like to believe, and what I've seen over my career as a prosecutor and the respect for the courts is, most prosecutors, most judges that I have dealt with and what I've seen across the country, I have to stand up and say color was not part of it, sir.
You and I need to have a cup of coffee or a drink or two or something, so that we can hash it out rather than
I'd love to.
here in the Rules Committee. My experience is entirely different than yours, and I believe that history proves that harsher penalties don't necessarily equate to lower crime rates. The thing that this legislation does that's troubling to me, and I think Ms. Jackson-Lee has pointed it out, and that is the Sentencing Commission has been about the business of doing a substantial amount of research. I might add, just for your information, at the time that the sentencing guidelines came into existence, close to 95% of federal judges opposed it. Among the things that we've seen is taking away that discretion that you say that a judge may in camera bring the prosecutor and the defense attorney and say, I'm not so sure about a mandatory sentence. But I'm telling you, all you have to do is look at this nation's prisons, and you will see people of color. And then before you came to Congress, Ms. Jackson Lee and I were here, Mr. McGovern was, none of the other members on the Rules Committee were. Mr. Woodall probably was staffing during that period of time. But we went through this awful period of crack cocaine being treated one way and powder cocaine being treated another.
Which I never agreed with.
Yeah, well, I'm
As a
delighted to know
prosecutor.
that, because it wound up with a hell of a lot of black people and Latino people in prison, a whole lot of white people not going to prison for the exact same thing. And that's troubling. And I don't care which way you cut it, the Sentencing Commission should have been inquired of more. The Energy and Commerce Committee felt that they were frozen out of what happened in the markup, and that is particularly troubling. But I think Ms. Jackson Lee's amendments would be curative, and toward that end, Madam Chair, I certainly support them being made in order.
Please let me know when
Mr.
you want to have
Hastings.
that cup of coffee.
We'll do that.
Mr. Hastings, may I briefly comment?
Sure, Ms. Jackson.
Let me thank you for that overview, particularly from the federal bench. I know that my good friend, who I enjoy being on the Judiciary Committee, did not suggest any lacking in common sense of anyone that's in this room. We may have a difference of opinion. But I think the amendment on the mens rea that I offer, as you well know, the mens rea standard could be utilized and it could be rejected. The idea is that none of us are on the streets with these individuals. We're not suggesting that these are not bad actors, but drugs that are laced, giving extra measure of determining whether or not this low-level person, whether they read the New York Times or not, had the mens rea to sell this, is an important component to diminishing the over exercising of mandatory minimums and incarceration of persons. A person may not be completely relieved of the burden, but they will have a lesser sentencing because of the lack of the mens rea. But the other point I'd like to conclude on, you're absolutely right. The Sentencing Commission has expressed concern, and they've done extensive work. And what do we do with that work? And they've done scientific work. So I hope that we can find a common ground on fixing aspects of this legislation that will turn us back into where we were before, Mr. Hastings, as you have so articulated.
Madam Chair, I ask unanimous consent to include in the record a letter dated July 11th in 2017, and it came from the Leadership Conference on Civil and Human Rights, and I think it's just as relevant today as it was a year ago when they submitted it, and I've seen nothing different. As a matter of fact, there's some 60 organizations that are in opposition to this measure, so with your permission.
Without objection.
Be made a part of the record. Thank you, Madam Chair. I yield back.
Gentleman yields back. Gentleman, Mr. Woodall, seek time. Any other members of the panel seek time? Ms. Torres? With that, the hearing portion of HR 2851 comes to a close. We'd like to thank you both very much for being here today, and we'll now bring up the witnesses for HR 5735.
Thank you.
Thank you. Mr. Barr from Kentucky. Is Ms. Waters here? And Mr. Rohrbacher from California. Is the gentlelady from California joining us? Thank you. Ms. Waters, yep. Thank you. Great. Mr. Barr, we'll start with you. The gentleman from Kentucky is recognized.
Thank you, Madam Chairman, and Ranking Member McGovern, and members of the Rules Committee. Thank you for the opportunity to speak before the House Committee on Rules regarding my legislation, H.R. 5735. the Transitional Housing for Recovery and Viable Environments Act, or the THRIVE Act. I also want to thank Chairman Hensarling, Chairman Duffy, and my colleagues on the House Financial Services Committee for their support and feedback on this legislation. This week, the House is considering several important pieces of legislation to address the opioid addiction epidemic that takes the lives of 116 Americans every day. My home state of Kentucky has the third highest overdose mortality rate in the country. In order to achieve meaningful progress in the fight against opioid addiction in our nation, Congress can no longer simply focus on prevention, enforcement, and treatment alone. We must also begin to implement policies that focus on long-term recovery. Our federal housing programs are an underutilized resource in these efforts. The THRIVE Act would make supportive housing more accessible to those most in need by allocating a limited number of Section 8 housing choice vouchers to nonprofits that provide housing, workforce development, job placement, financial literacy, and continued addiction recovery support, such as 12-step programs for individuals who are transitioning out of rehabilitation and back into the workforce. Rather than allocating the vouchers through public housing authorities, this demonstration would give vouchers directly to housing nonprofits that meet evidence-based metrics of success on a competitive basis. The vouchers would be distributed with a focus on regions of the country with the highest rates of opioid-related deaths. This legislation would only allocate either $10,000 or 0.5% of total housing choice vouchers, whichever is less, to people who are literally dying every day of opioid addiction and other substance abuse disorders. And the demonstration is limited to 5 years. Congress has done a good job, or a decent job, in addressing this epidemic from the standpoint of prevention and education, from law enforcement and treatment, particularly with the Comprehensive Addiction Recovery Act, the 21st Century Cures Act, and the most recent appropriations bill. However, experience tells us that, unfortunately, we have fallen short when it comes to post-treatment or post-incarceration or post-emergency room recovery. So in other words, what often happens is that when someone emerges from incarceration or when someone emerges from a period of medication-assisted treatment, a short-term stay at a rehab facility, 30 days, 60 days, or 90 days, they emerge from that environment literally penniless, having exhausted all of their resources, and they literally have no place to live because they've typically severed their ties painfully from their families. And so what a lot of these not-for-profits in my district have told me is that these folks end up back on surfing couches, back in the very living arrangements that got them into trouble in the first place because they literally have no resources. And oftentimes they go back to living with people who are continuing to struggle with active addiction. That is not the environment. That is not the housing environment that is conducive to long-term sober living or long-term recovery. The THRIVE Act would save American lives as well as taxpayer funds in the long run by helping more individuals rise above addiction and poverty. Now, it is in this spirit that I offer a manager's amendment to introduce improvements to H.R. 5735, the THRIVE Act, based on feedback we've received from various stakeholders as well as technical drafting assistance from the U.S. Department of Housing and Urban Development. And I will add, Secretary Carson visited several of these not-for-profit organizations in my district, and he asked for additional flexibility in the form of what we're trying to do here today. But the professionals at HUD gave us some constructive suggestions that would alleviate some of their concerns. And these changes in this manager's amendment include clarifying the distinction between illicit drug use and medication-assisted treatment, requiring nonprofits to show that they have experience administering housing programs and are in full compliance with the Fair Housing Act and the Civil Rights Act of 1964, requiring HUD and eligible entities to coordinate with the Department of Health and Human Services, the Department of Labor, and local workforce development boards, because again, what we're talking about here is often job training and addiction recovery services, eliminating the 12 to 24-month time limit for individuals in the program, authorizing waiver authority, allowing HUD greater flexibility to administer the program while still requiring full compliance with statutes and regulations, related to fair housing non-discrimination, labor standards, and the environment, and other technical changes. I would like to thank my Democratic colleagues, including Congresswoman Sinema, for suggesting several of the improvements to the bill that are included in this amendment, and I'm hopeful we can work together in a bipartisan manner to improve housing options for individuals recovering from opioid addiction and other substance abuse disorders. I yield back, and I'd be happy to answer any questions.
Barr, thank you very much. We're delighted to have the gentlewoman from Los Angeles, and she's now recognized.
Thank you very
Yes,
much.
ma'am.
Mr. Chairman and Ranking Member and members of the committee, I certainly appreciate the opportunity to testify before you today on H.R. 5735, the Black Act, introduced by Congressman Barr. I appreciate the good intentions of Mr. Barr, as there is no doubt that we need more housing assistance for people with substance abuse. Substance use disorders to help them recover and rebuild their lives. And I certainly appreciate the fact that in response to concerns raised by Democrats, Mr. Barr amended his bill to cover all persons with substance use disorders rather than creating preferences for just one type of disorder without providing the same help to others. However, without any new funding, and let me just say that again, without any new funding, to enable the creation of new vouchers, this bill would effectively tell millions of people who have been waiting in line for a housing voucher that they have to wait a little bit longer because Congress decided to let some people cut in front of them. These are families with young children, elderly and disabled households, veterans, persons experiencing homelessness, and other people in need who in many cases have been waiting years for a voucher. This is simply unfair. If we agree that we need more housing assistance for people with substance use disorders, let's agree to provide the funding necessary to create new vouchers instead of taking and redistributing vouchers from other families in need. Further, this bill would place harmful time limits on the housing vouchers set aside for this new demonstration by limiting housing assistance to just 2 years. Mr. Chairman, 2 years is not going to be enough time for people struggling with substance abuse to both fully recover from their addiction and to attain stable employment that allows them to afford market rents. Terminating housing assistance before individuals can maintain stable housing on their own could very well contribute to relapses and be counterproductive to the very intent of the bill. Lastly, under this bill, the vouchers set aside for the new demonstration would be taken away from public housing agencies that normally administer them and then allocated to new eligible nonprofits. This would effectively result in an unfair distribution of vouchers to areas that would be targeted under this legislation, which would negatively affect the funding levels of certain public housing agencies due to the loss of vouchers, because public housing agencies are currently the only entities authorized to administer the Housing Choice Voucher Program. It is also questionable whether these nonprofits will be able to effectively administer a program that they have no experience administering. I also understand that Mr. Barr will be offering a manager's amendment that attempts to address some concerns, and I guess he has. However, this amendment does not address the lack of funding and may actually create new problems by giving the Secretary broad authority to waive requirements that would otherwise apply under the Section 8 program. In fact, this broad waiver authority could very well be a backdoor for the HUD Secretary to implement harmful rent increases on tenants along the lines of what he has proposed in his so-called, quote, Making Affordable Housing Work Act, quote, unquote. It has also come to my attention that there is a significant disagreement between the majority and the Congressional Budget Office on how this bill should be interpreted. The last-minute changes in the manager's amendment, as well as this disagreement with CBO, highlight the fact that the Republicans are inappropriately rushing the consideration of this bill to the floor. Democrats believe the issue of housing for persons dealing with substance abuse disorders is an important problem to solve. Mr. Cleaver, the ranking member of the Housing and Insurance Subcommittee, offered an amendment in committee that would have addressed our concerns by providing funding necessary for 10,000 new vouchers, allowing PHAs to administer the vouchers, removing the harmful time limits that the bill imposes, and ensuring that rents remain affordable. Unfortunately, Republicans rejected the amendment, and I have submitted that same amendment today. And I would urge the committee to make that amendment in order so that individuals with substance use disorders get the housing assistance they need without penalizing other needy Americans. 28 national housing, behavioral health services, and recovering housing organizations have come together to oppose this legislation, including the Center on Budget and Policy Priorities, the National Low-Income Housing Coalition, the Corporation for Supportive Housing, Community Catalyst, the Council of Large Public Housing Authorities, the Public Housing Authorities Directors Association, and the National Association of Housing and Redevelopment Officials. Mr. Chairman, I certainly think it is telling that such a broad coalition of groups dedicated to affordable housing and recovery from substance use disorders oppose the bill. For all of these reasons, and even more that I've not been able to get into today, I cannot support this legislation, and I would encourage my colleagues to oppose it. I thank you, and I look forward to taking your questions.
Ms. Waters, thank you very much. We're delighted to have the distinguished gentleman from California, the gentleman who I see most mornings and share not only morning conversations, but admire him for his service to the United States House of Representatives, more people to the people of California. Gentleman is recognized. Mr. Rohrabacher.
Thank you very much, Chairman Sessions and Ranking Member McGovern, and the rest of the Rules Committee as well. Thank you for having me here to speak about my amendment to H.R. 5735, the Thrive Act. And thank you to my friend and colleague, Congressman Barr, for his willingness to work with me and cooperate on my amendment. We know that the opioid addiction epidemic has wreaked havoc on our people, and this bill aims to help those struggling to recover by providing financial assistance to supportive housing facilities that offer treatment options and an environment conducive to recovery. Unfortunately, many such facilities, better known in my area as sober living homes, are not providing the environment they promise and cause serious problems for the residential neighborhoods in which they are located. Many regions of our nation, including in my district of Orange County, California, we have seen a huge increase in the number of these facilities in single-family homes in recent years. Inhabitants of the facilities are often recruited from all over the country, and if they fail to get clean and relapse and end up taking drugs or whatever it is again, they end up homeless and on our street. Federal law that protects addicts from discrimination in housing has shielded unscrupulous owners, operators, and the inhabitants of these so-called sober living homes from meaningful oversight when they are not doing what they should be doing, and they are also in the process of disregarding the wishes of the communities around them. The problems are many, including increased police activity. We've seen an incredible increase in neighborhoods where we're once safe, and once you have people being brought in, drug addicts and alcoholics, the crime rate goes up. Surprise, surprise. Overcrowding and concern for the diminishing quality of life in these neighborhoods is of deep concern to my constituents and should be a concern to all of us where we want to help one people, but not at the expense of others who have been trying to live their lives all along in the right way. While we are not dealing with those problems in this bill, my amendment would ensure that the federal government does not contribute to and exacerbate these problems by subsidizing bad actors, meaning people who are not running these facilities in the right way and are putting them in the wrong locations. It would require the organizations that receive federal money and distribute it to these sober living homes provide proof that the local governments with jurisdiction over the zone where this facility is located will have authorized it to operate there. Thus, we are empowering local government to utilize zoning and utilize their judgments as to whether or not these are the right places for the safety of the community and not only the safety of the community, but the success of the treatment of these people we're trying to help. It is a small but critical change in the bill that makes sure that the federal government is not making the situation worse for communities while attempting to do good things for drug addicts and alcoholics. And we know that the people in local areas understand their areas much more than somebody from the federal government would have. So thus we've included local people in the decision-making process. And I thank you again for giving me the opportunity to speak on the amendment. I urge you to vote in favor of this amendment, and I'm very pleased that Congressman Barr has accepted this as co-sponsoring the amendment.
Mr. Rohrabacher, thank you very much. Your testimony is also sobering reality that we all face. Well, it can be seen in a light that it really is. If you walk across rural districts, suburban districts, urban districts, all across this country, we are dealing with an addiction problem. Before the gentleman arrived today, I entered in the record a brand-new article dated May the 31st, recognizing that was some 11 days ago or 12. More drivers killed under the influence of drugs than alcohol. And I quoted the article, some 22.3% of fatally injured motorists were tested for drugs, tested positive for marijuana in 2016. Researchers say that it has increased substantially in recent years as states have legalized the drug for recreational or medical use, according to the report. It goes on and on and on and on to say that what is happening is people are getting into their automobiles. This is no longer just for home use. It is a terrible problem in our nightclubs. It is a terrible problem, not just marijuana, but these other drugs that are very destructive. And it's created an addictive society. And as you know, anyone with children, as we all have them, it's a terrible thing for our children to have to come into contact with, sometimes late at night, sometimes in the middle of the day. These things are reported over and over by the Dallas Police Department. Yes, sir.
Thank you. I happen to live across the street from a sober living home. And this was about 6-7 years ago. And I have a 6-year-old son, and I come out one day, and there's a drug addict, unescorted, no one there but this drug addict and my son. Now, I don't know what would have happened, maybe nothing. But I will tell you, it is wrong to put these sober living homes right in the middle of residential areas where people have children, and it's wrong. And I called him in. I didn't do anything else, but I can only imagine that if that happened to me, what's happening throughout the whole community. And we have been inundated with sober living homes and in Orange County, California. And it's just, we got to make sure that we have local people help part of this decision-making process so they don't feel like their quality of life and their life is being threatened.
Yes, sir. Well, I think the point that you made, which is most appropriate, and that is families that are attempting to raise their children should be protected in this process also. As you know, I'm struggling, as we all are, on this addiction issue. What might seemingly be a helping hand can turn into a very difficult circumstance where addiction has ravaged them, and it's hard to know. What I also said earlier is Health and Human Services last week held their first, what I think is their first and demonstrated national issue of dealing with, from Health and Human Services, the opioid addiction issue from across the country, where they brought in experts, and the gentleman, Dr. Brett Jarrah, the Assistant Secretary for Health, and the gentlewoman, the Chief Medical Officer of Health and Human Services, Dr. Vanila Singh, ran this meeting and took feedback from the front lines of this country about what they're seeing and what might be avenues of expressive help and facts of the case. And I do thank each of you for being here today. Dr. Burgess?
Thank you, Mr. Chairman, and appreciate the gentleman bringing up the issue of problems with sober homes. We have had several hearings in the Energy and Commerce Committee, both in the Subcommittee on Oversight and Investigations and the Subcommittee on Health. And some of really the most tragic testimony that we've received has been from family members. In fact, there were two individuals, both of whom had sons, both of whom were cycled through sober homes and recycled. It's almost as if there's an incentive to fail because it perpetuates the treatment climate and then therefore perpetuates the reimbursement. And unfortunately, a person can only fail so many times before the disease will ultimately claim them. And that we unfortunately did hear testimony from two mothers who had lost sons in so-called sober homes. We also heard from a district attorney in Massachusetts who's had lost several of his constituents in homes in Florida. They had been attracted through advertisements on the internet, brought into these homes, again, cycled through over and over and over again. The treatments were repetitively ineffective, but always covered until the individuals just simply wore out and were unable to, again, they died of their disease, is essentially what happened. They overdosed. I'm sorry, Mr. Barr, did you have a question?
No, I just would like to just comment on that if I could. First of all, let me just thank my colleague from California for offering the constructive amendment, and I agree to the amendment because that's precise. We certainly do not intend to have unlicensed facilities in proximity to children or anything like that. In fact, and we also don't want to have these kind of models of failure where you have kind of recipes for relapse. The way that this legislation has been crafted is modeled after effective addiction recovery transitional housing models, evidence-based, that are living environments of accountability, where there is financial literacy, where there is mandatory savings, where there is routine accountability in terms of 12-step programming. It's not just sheltering an addict. That's what's different about the Thrive Act. And I'm more than happy to accept the gentleman's amendment because we certainly want to avoid those failed models. What we want are these evidence-based models. Many of them are faith-based. They don't have to be, but some of them are, and they're not-for-profits. They utilize work and job training and getting back into independent, self-sufficient living as part of the recovery process. And so they stand out as models of success with high rates of long-term recovery. So appreciate the gentleman sharing those heartbreaking stories of failure. We're trying to offer a demonstration model that's very, very different than those examples.
But I would
Mr.
just add,
Chairman.
the issue of local control is one that's of paramount importance, because oftentimes, the gentleman from California is quite correct, that people on the ground know what's going on probably better than anyone else. Mr. Chairman, I'm sorry, did the gentleman have?
The gentleman, I believe, does see that the gentlewoman from Los Angeles is seeking his attention. The gentleman controls the time. Does the gentleman wish to continue?
Yes.
Gentleman is
I'm
recognized.
happy to give the gentlelady an opportunity. to
Thank you very much. I just wanted to respond to what I'm hearing here about two issues. One is the most important issue, I think, is the fact that we're going to take from existing vouchers from families that have been waiting in line with children, et cetera, instead of recognizing that we need additional vouchers. We have to spend some money. You want to try and do this on the cheap, it won't work. That's number one. Number two, the other issue that my colleague from California is talking about is kind of a NIMBY issue, not in my backyard. And that's okay, I get that. But the fact of the matter is, this amendment does nothing to make sure that the locals are dealing with your concerns. These are laws in the state of California that allow the development of these places, and simply because you don't want them in a certain area, it does not work. You have to change the laws of the state of California. This does not do that. The other thing is this, this business about the opioid epidemic, how terrible it is, and how some members are experiencing this in their districts for the first time. Some of us been living with addiction disorders for all of our careers. We were not able to get assistance. We have seen people die. We have seen folks, whole communities destroyed. And I get it. I get it that now that we have opiate addiction, in some areas where it's not been before. I was in Mormon territory, and I saw what was happening there. I get it. So if we want to deal with this, let's deal with it in a comprehensive way for everybody with these kinds of disorders. Let's put some money into it. Let's talk about how we work with locals, but let's not believe that somehow this amendment is going to change the laws of the state of California. We can't have it both ways. You can't have it in such a way that you want to deal with this opioid addiction, but you don't want to spend any money on it. You don't want them in your neighborhoods. What are we talking about? We should be talking about comprehensive response to these addictions and these disorders. It's going to cost money in order to deal with it, and it's going to cause us to have to work with the local communities in ways that we have not done before. This business of creating new nonprofits because you don't want to deal with public housing, because public housing may be dealing with people who are not worthy as much as people in these new nonprofits that you would develop in your neighborhoods who would now try to administer something they know nothing about. I think that we should look at all of these issues in a very serious and comprehensive way and not talk about trying to take away vouchers from needy families who have been waiting in line for years, number one, and not talk about creating new nonprofits that have no experience and no backgrounds in order to do this work. We know many of the organizations who have been dealing with this kind of these disorders for years, who have been underfunded and who have been struggling, and they're still struggling.
Let me just reclaim my time, and
Yes.
I'm going to yield back in the interest of the fact that we will have votes on the floor, but we are taking a comprehensive approach. And again, more money has been put into this problem last Congress and this Congress than historically has ever happened before, and our work's not done. So I'll yield back.
Gentleman yields back his time. Thank you very much. Excuse me just a moment, please, sir. Excuse me just a moment, please, sir. I respect that the gentleman would wish to offer a rebuttal, and I respect that. this committee ask the questions. And I'm sure that you'll have a chance between one of our other members who will have that opportunity to advise the gentleman, to engage the gentleman on the issue. Thank you very much. Distinguished gentleman from Massachusetts.
Yeah, well, it looks like we're going to have to come
Yes,
back
sir.
after
Yes, sir, I get
vote,
that,
so,
too.
but I want to spare this panel from having
Yes,
to
sir.
come back.
I-
So
that's why
I'll
I'm trying to-
associate myself with Ms. Waters and yield back my time.
Thank you very much. Is there any other member down this committee, down this side that would seek time? Gentleman from Florida.
I too will be brief. First, let me make it very clear. I don't think HUD has any experience in substance abuse disorder, period. I've worked with FHA before it became HUD and public housing. I certainly know that Mr. Barr's intentions are good. The question that I have, for example, Mr. Barr, in public housing, I was an attorney for the Public Housing Authority in Fort Lauderdale, Florida. And over the course of time, vouchers or not, however people got there, we didn't want anybody to be there if they had the substance abuse or problem. So this is kind of counter to what you're talking about. Ms. Waters' point is well taken. I will only offer one thing to you to consider. We have a restriction that has been in force in effect here for 32 years to stop facilities that are people that know how to deal with drug addiction. They're limited under Medicaid to 16 beds, and they have for years been trying to get that expanded so that they could deal with many of these problems and have the housing that's necessary for the protracted period of time that is necessary for people that are addicted. I'll leave it at that, Mr. Chairman. There's much more that I wanted to say, but you can't have 7 million people in this country that need to have housing, and they're not going to get it under the present thing unless we're willing to spend some more money. And I think your pilot program ought to be undertaken, but it ought to be funded.
Thank you very much. Is there any other member of the committee on my right side that would choose to be heard? The gentlewoman from California, Ms. Torres, is recognized.
I apologize,
We're delighted that you're here.
Chairman, that I have quite a bit of experience on this issue, 4 years as a chairwoman of Housing and Community Development in the state, and before that, 5 years in local government. I have dealt very deeply into issues of rooming houses, sober living homes. I can tell you that if you are an irresponsible sober living operator, you can you go to a city where the rents are extremely cheap, and you would rent out blocks. Doesn't matter, because you can turn every single room in that house except for the bathrooms and the kitchens, and you can put bunk beds in every single room. And that's how they operate. You only have to have a state license if you room 7 or more people in California. So the issue really comes down to the haves and the have-nots, because those cities that are more affluent and have a more involved community will always turn to the NIMBYism and state and take their concerns to their local governments, who will do anything and everything to keep these facilities from being operated in their communities. And that is very unfair to cities like my home city. We don't have a choice. These people come in, and there are no additional services that are provided for cities that are hosts to these. Mr. Barr, I wanted to start, and I apologize for not congratulating you on all of your work that you have done around child abuse. And I hope that I can work with you on those issues and the work that you are doing to help protect veterans in your community. You're to be commended for that. On this legislation, I heard your comments, and I very, very much agree with much of it. I think our disagreement comes at the lack of vouchers. In the state, up and down the state of California, I hear a lot about the need for transitional housing and the lack of infrastructure that currently exists, and that's unfortunate because we do need to have that. 25,000 foster kids who age out of their homes every single year need to have that interim place to go. We talked about victims of domestic violence. We talked about incarcerated or formerly incarcerated people that have no place to go. The rents the housing prices are growing in every state in the union. California has risen by 7%, 8.6% in Colorado, Washington by 13%. So the need to add more dollars to these programs is critical. So I wish we were adding 10,000 new vouchers versus taking 10,000 vouchers from current use because we need them. We need those extra vouchers. I hope that this amendment will be taken in order because I think it is moving in the right direction. If we truly care about people that are trying to be sober, then we need to help. We need to regulate. We need to ensure that the people that are trying to help them are not just an appointed self-supervisor from, that is a current tenant of the household, but it is an experienced person that could be licensed and bring actual benefits to the people that are living there as it relates to sober living homes. But the vouchers are needed, the infrastructure is needed, and we shouldn't be taking away from a program. We should be adding to the program. I yield back.
Thank you very much, Chairwoman. Yields back her time. Is there any other member of the committee that would seek time? Seeing none, I want to thank this committee. Before we leave, the gentleman's recognized for 1 minute.
Thank you, Mr. Chairman. So the theme that has come up is that we're taking away vouchers. I just want to take issue with that. So remember who these people are. They are penniless. They have no resources. They are otherwise eligible for Section 8 housing choice vouchers. We're not talking about displacing people who are eligible with people who are not eligible. These people are eligible for Section 8 vouchers. They have no resources whatsoever. They've exhausted them, number one. Number two, this is a demonstration project totaling a grand total of 0.5% of the entire allocation. Remember how HUD does this. They don't distribute vouchers. They appropriate allocations. It is up for the public housing authorities to efficiently administer to maximize the number of vouchers. It doesn't mean we displace a single low-income eligible person from a voucher. Third, it doesn't require a zero sum because public housing authorities can administer these much more efficiently. By the way, the manager's amendment also takes away the time limits on these, but time limits, and I agree, the whole point here is long-term transitional housing. But no time limit whatsoever after 2, 3, 4, 5 years. That's part of the reason why we have waiting lists in Section 8 to begin with. We have intergenerational, able-bodied, work-capable adults that are denying access to disabled senior citizens. It's not a lack of resources, it's a lack of efficiency. That is precisely why this legislation creates a demonstration project to bypass inefficient public housing authorities to provide an opportunity for evidence-based nonprofits who efficiently administer these through faith-based models to do something different, to innovate, to try something different than the public housing bureaucracies and actually get results. And with that, I yield back.
Mr. Barr, thank you very much. I've got one last question. You said this is a trial or we're trying to see whether this would work. How much money would you anticipate would be utilized in an appropriation cycle to support H.R. 5735?
Well, it would be a very small amount. The legislation specifies a total of 10,000 vouchers. Efficiently administered, that is a small fraction, 0.5% of the total annual appropriation. What I would say, as an olive branch to any member who's concerned about cannibalizing the Section 8 housing choice voucher program.
Mr. Barr, let me say this. I would encourage you between now and the time you are on the floor to come up with an answer that might fully satisfy that amount that you believe would be supported by an appropriations request.
I will.
And I know that you'll have that
I will have
opportunity
that.
to do that. And
I
I'm
will.
sure you know and I know this is policy when it comes later. I want to thank the
Thank you.
gentleman, distinguished gentleman, for being here.
And Mr.
Yes, sir.
Mr. Chairman.
The gentleman's recognized.
This is a demonstration project.
I recognize
And
that, sir,
let
but-
me
but-
just stress, we need a demonstration project on this. It's failing out in California. We have all of these sober living homes, and 3/4 of the people who go in them are not helped because we don't know the system. This is what we're trying to do, is learn it and give local people some power to form this so that their people who are addicted to drugs and alcohol will have a system that works. So I just, that this is a demonstration project
Okay, well,
means a lot.
Let me say to the panel, you have very effectively sold 3 cases today. And I encourage each of the participants who have been here today to recognize this committee is going to have to take on the amendments that might be presented in attention to that. I would encourage each of you to know that you'll get your chance on the floor, and I would go sell the fight there. But it is my hope that the gentleman from Kentucky would recognize, I think answering that question of dollar amount would enable him to have a better chance to sell his piece on the floor. If you'll please make sure you leave whatever you brought in writing for Austin Stogford and allow her to complete the record today. Thank you to all 3 of you. We now find ourselves in the circumstance where we are going to get through opening statements on the next panel, and then we're going to try and see if we can get done. So is there any other member that would seek to give testimony of H.R. 5735? Seeing none, this now closes the hearing portion of that. Is there anyone who'd give testimony H.R. 2854? I'm sorry, 54. Seeing none, this now closes the hearing portion there. We would now instruct the clerk to please ask the gentleman, distinguished gentleman, Mr. Brady, Mr. Pasquale, Mr. Bishop, to please, Mr. Coach, if you'll please come on in, take a seat. We're going to try and get through our opening statements. We're trying to recognize that this evening we have members that are engaged in business, as well as this committee that's trying to appropriately finish our time. I thank the gentlewoman for the clerk for seeing if we could get Chairman Brady, who I know is in my office. Is the gentleman no longer there? Thank you very much. We appreciate that, Angela. The distinguished gentleman, Mr. Brady, will be here shortly. Mr. Pascal, I'm going to go ahead and, without objection, begin the testimony that you might start. Please understand that without objection, anything you brought in writing will be available to the record. The gentleman is asked to go ahead and give his testimony with the knowledge that the gentleman, Mr. Brady, will follow you. Gentleman's
Yes, sir.
recognized.
Thank you, Mr. Chairman. I'm pleased to be before the Rules Committee regarding a bill that we've been negotiating for many months, and that deals with an incredibly important topic, the opioid epidemic that has a devastating impact across our country. I want to thank Congressman Bishop. I want to thank Senator Portman. And thanks for the work of their staffs. Excellent, excellent work. Because we've worked out, we think, most of the difficulties. Despite current efforts, this opioid epidemic continues to devastate communities. We're losing 115 Americans every day. In 2016, my home state of New Jersey alone experienced 2,056 lives lost to this epidemic. The Attorney General's office predicts that the number this year is going to surpass 3,000. This legislation addresses one aspect of the crisis: synthetic opiates making their way into homes across the country through mail. According to the Drug Enforcement Agency, China is the primary source of the fentanyl that enters the United States. Fentanyl is often sold online, then shipped to the United States, as I've seen in post offices, many of the depots I've visited myself. I saw firsthand the way that the USPS and the CBP, the Customs and Border Patrol, are working together to stop the flow of these synthetic drugs through international mail. I visited just a little while ago, 2 weeks ago, a mail facility in Secaucus, New Jersey, with representatives from Customs, the Federal Drug Administration, U.S. Postal Service. The USPS receives an overwhelming volume of mail, and they're working hard with limited resources to screen shipments. We have some clear strategies that we can employ to create an effective system for targeting shipments that have a risk of containing these opiates, namely collecting advanced electronic data, or AED, advanced electronic data, or on packages that enter the United States. The information contained in this advanced electronic data typically includes the name, the address of the shipper and the recipient, as well as the contents of the package. The CBP uses this information to identify packages that may pose a risk. CBP can then place a hold on the shipment, notify carriers that a package must be presented for examination. Private carriers have been required to collect AED since 2002. The U.S. Postal Service has been exempt for a number of reasons, including its international obligations as a governmental entity. This bill will establish a strong but reasonable approach to the SPS to eventually collect AED on all international mail, all mail shipments coming into the United States. I want to highlight a few provisions very quickly that have been key to getting the support. The legislation requires USPS to collect 70% of the advanced electronic data by the end of this year. As part of the requirement, USPS will be required to collect 100% of the advanced electronic data on packages coming in from China. Given that, numerous reports have highlighted that China is the main country of concern on this issue. I think this is a valuable provision. USPS should be focusing its immediate efforts on high-risk countries, and this legislation lays out a clear requirement in that regard. Second, the legislation requires USPS to collect 100% of the AED by the end of 2020. So we will graduate to that, Mr. Chairman. I think this is a laudable goal, an aggressive timeline, but I also think it's important to recognize the unique circumstances of the USPS. That is why I support the provision in the perfecting amendment that exempts countries without the ability to collect AED and that pose a small risk to the United States from this requirement. This provision recognizes the USPS's international obligation and its reliance on foreign posts to collect their AED. I also like to highlight where we've landed on a provision to create penalties on the USPS for failing to collect AED. This was a bit controversial, but we've worked among Ways and Means, the House Committee on Oversight and Government Reform, Senate Finance, Senate Homeland Security, and Government Accountability regarding the effectiveness of this provision. In my view, if the USPS continues its work collecting AED from foreign posts, these penalties will never be imposed. Finally, I'd like to highlight a report directing the CBP, Customs, to provide an annual report on the individuals and companies that are not providing AED and the manner in which it imposes penalties. By requiring CBP to report this useful information on violators and violator penalty assessments, I believe that we will enhance CBP's interdiction of prohibited items from entering the United States through express consignment operators. I would like to thank my colleagues, all of them. Mr. Chairman, worked hard on this bill. With me on this legislation and the rest of everyone, the chairman, as reflected in the manager's amendment and the perfecting amendment. I believe that the legislation before us today reflects a bill with strong bipartisan support. This support was reflected earlier today at the Senate Finance Committee. The opioid epidemic is a serious problem affecting our communities, and it deserves serious policies, excuse me, in response. And I'll just end by saying this, Mr. Chairman. I am a zero tolerance in terms of drugs. I was a teacher, I was in the service, and now that I'm here, zero tolerance means that. And so my approach has always been, regardless of all the bills that we just passed on the floor, I ran upstairs here for this, no market, no sale. We need to do more about the market, Mr. Chairman, the demand, because we'll put people out of business if there is no demand. We need to approach that this way. And that's how I'm approaching opiates.
Mr. Pascal, thank you.
I'm sorry it's too long.
You have done so well that I'm going to ask you to come back. We are now at 0 minutes. Mr. Chairman, I know you've been here at least an hour. Mr. Pascal, I appreciate this. I've asked that both of you please come back before the committee. We'll hustle through this as quickly as possible.
Perfect.
But, Mr. Pascal, I could not agree with you more. The committee will now be recessed until after the last vote, and we'll come back and call the chairman.
Thanks, Chairman.
Rules Committee come to order, and thank you very much for rejoining us. We appreciate Mr. Pascal beginning the conversation and his viewpoints about this bill. We also want to recognize the distinguished gentleman from Ways and Means Committee needs to address this. This is a serious issue. It is one that is a daunting task before not just the American people, but this Congress also. And Mr. Pascal's words of support and wisdom of doing things is correct. And I also know Mr. Bishop is here for his distinguished work that he has done. So I don't know how you would like to proceed, Mr. Chairman, but I'd like to recognize you first for any comments you'd like to make without objection. Anything all four of you or any of the witnesses bring tonight will be made available to our stenographer on a priority basis. The gentleman's recognized.
Thank you, Mr. Chairman, Ranking Member McGovern, members of the Rules Committee. Good afternoon. Thanks for allowing me to testify, and I will submit the my opening record statement for the record. I'm joined by Mike Bishop of Michigan and John Fass of New York, who, along with Ranking Member Pascrell and Chairman Reichert, are the leaders of this important legislation. As Mr. Pascrell said, there is too much. There are too many synthetic opioids like fentanyl being smuggled into the United States through international mail. That's the easy route to do it. While private carriers have been required to submit advanced data to U.S. Customs Border Protection on all shipments for more than a decade, that's not the case for the U.S. Postal Service. So this means the illegal shipments have an easier route into the United States through the mail. So the STOP Act will close this loophole by requiring the Postal Service to transmit advanced data to Customs on all international shipments by the end of 2020. This data is desperately needed by Customs to fight the flow of illegal drugs in the United States. To ensure compliance, STOP Act will establish civil penalties if the Postal Service accepts mail shipments without advanced data after 2020. It gives the Customs Commissioner authority to modify the penalties if he makes specific findings. It directs the State Department to strengthen international postal agreements. And in closing, I do want to thank, again, Congressman Bishop for his leadership, Congressman Faso, Ranking Member Pascrell, and Subcommittee Chairman Reichert for their good work. And I yield back.
Chairman, thank you very much. Mr. Bishop, the evidence seems to suggest that you have spent a lot of time on this, and the gentleman, Dr. Burgess, who was here a few minutes ago and may come back, I'm sure will want to engage you on this important topic, as he, as you know, serves as the subcommittee chairman for health in that distinguished committee, Energy and Commerce. The gentleman, Greg Walden, is the chairman of that committee, and Mike Burgess serves as the subcommittee chairman. So we're very aware that the jurisdictional element that you bring tonight is well within your realm, but we also recognize that much of the information that we're discussing tonight applies to all members almost equally. And so we have had a most vigorous debate all day on this important topic of opioids, opioid abuse, substance abuse, addiction, and we appreciate the time that you're taking today. The gentleman is recognized.
I think thank you, Mr. Chairman, Ranking Member McGovern. Pardon me.
Is your microphone on?
I appreciate the opportunity to address the committee. I think the chairman was comprehensive in his remarks. I won't go any further, other than the fact to say that we've all had hearings around our district. We've heard from constituents. This is a real issue. Fentanyl, carfentanil, the synthetic opiates are a real problem. They're killing our friends, neighbors, family, our children. And we recognize how they're getting into this country from the real flaw in our system. It's obvious. We have a chance to close that gap now. And I think it's really a no-brainer for us to move forward on this and address it as soon as possible. The bill presents a real solution to a real problem. And I'm very pleased to be able to be a part of this. I'm grateful to the chairman for his leadership on this, Mr. Faso for his leadership on this as well, and look forward to supporting this on the floor on Thursday.
Thank you very much. Mr. Faso, we're delighted that you're here. The distinguished gentleman has been here much of the afternoon, and I appreciate him taking time on this important issue to represent not only his constituents, but perhaps more importantly, the American people that are looking for Congress to act and speak clearly. And I think Mr. Bishop said it best. We're going to address the issue in a great way. Gentleman's recognized.
Thank you, Mr. Chairman, Ranking Member McGovern, and members of the committee. First, I want to thank Chairman Brady and Chairman Reichert for all of their work, Ranking Member Pascrell for yeoman's service in bringing this matter through the committee and negotiating it and getting the agreement with the Postal Service and others who are affected by this. Representative Bishop this is an issue which he feels deeply about. I got involved for the very same reason. We lost 20,000 Americans last year from fentanyl overdoses. It's really astounding. And in every community in this country, people are astounded when they hear that much of the illegal fentanyl coming into the United States comes through the United States Postal Service. So this measure, which Chairman Brady is spearheading, is overdue, and it will bring us, I think, some measure of security when it's fully implemented. And I thank the committee and especially the Ways and Means Committee Chairman and the staff for all of their work in bringing this legislation to us today.
Thank you very much. For anyone on the committee, the Postal Service knows they've got a problem. And I don't understand enough, and maybe somebody can specify it cleanly for me, but do they have operations in China? How is somebody supposed to register and send things here? How does it come here, even if we don't have the address? How does it get in U.S. Postal Service mail? And where? What China? England? A ship? How does that happen? Mr. Chairman?
We think the answer has already been proven on the private sector side where that advanced data, the advanced data is required through the Postal Service just as it is for UPS, FedEx, others like that. It's shown to have worked. The challenge here is, A, to ensure that this is mandated for the Postal Service, that there are timetables. Mr. Pascrell talked about the timetables that we think are fair, but they're ambitious, aggressive as well, and that there's accountability. If this doesn't happen, there's consequences to the Postal Service because there's consequences in our communities and our families as well. And so I think we've worked very closely among ourselves on this solution, but also with Senator Portman, the Postal Service, others, to make sure that, in the private sector, to make sure this does what we want it to do.
So let me see if I can ask my question differently, because I asked it poorly.
I probably answered it poorly, Mr.
No, sir. No, sir. As a matter of fact, because of your brilliant tie, I've been focused on your tie today, Mr. Chairman. That's a joke, because I gave him another tie today for his birthday, and he didn't even wear it today. And I said, come on, Kevin. You're up here before the committee. No, you're doing just great. My point is, I was asking an open-ended question. How does it get to the United States Postal Service? Do they have a branch in China? Does it come through the Chinese mail that they then transfer it to the United States Postal Service? Is it shipped USPS from overseas? Does it? How does that happen? I'm looking for.
So I was remiss
Yes,
in answering. Here's the challenge. We rely on foreign postal services.
That's what I would have suspected.
And then, of course, there's various ways that the carriers bring it here to the United States. That's why this bill, which is comprehensive about that advanced data, that's our best shot.
We're in essence going to have to say to Chinese authorities, before you bring us a package that we accept, it's going to take that.
The advanced data is really critical.
And my take on it is, Mike, you're smarter than I am because you've looked at this longer than I. But I would be willing to be nice for a little bit, but not for very long. So my take on it is that my lens that I'm looking at this is we have a critical problem here, and it's really not something that's within the purview of a demand from the Postal Service. We're going to have to say to them, no, at certain date. in my opinion. So what do you think about that?
Say no at a
We're
certain
not
date.
going to take any package if you can't provide us the data.
The bill actually provides that there are strong law enforcement accountability provisions that will impose civil penalties against the USPS if they accept packages without the AED after 2020.
Okay. All right. Well, that's my point. I would just not accept, well, they won't accept any if they got a penalty. Good for you. Mr. Woodall, you've been here all day.
Thank you, Mr.
You
Chairman.
get credit for showing up early, on time, and sticking around. Gentleman's recognized.
I'm thinking about the mandate to develop technology to be able to identify these packages. And I'm thinking about our efforts after 9/11 to find technology to detect box cutters. What is the committee's expectation? That the mandate is for the Postal Service to develop specific technology to develop this specific threat, or develop broader technology to identify, well, it was crack, and then it was meth, and then it was heroin. I'm going down to the White House tomorrow, and a dog is going to sniff me again because we couldn't find a computer that was that could sniff me properly, and so the dog is going to do it. Mr. Pascrell?
Well, all of the above, because we've graduated the time so that we were going to move from 80% to 100% over a period of time, hoping that the United States Postal Service will have enough time to develop the technology. Part of it is there, but to develop it to the point that you've talked about. This is look, we have an epidemic. We have to approach it in a very different way. I use as the protocol for this the HIV attack that we had in the 80s and 90s in the United States of America. It was underground because nobody wanted to talk about it. We did not do much in the very beginning until we educated people, educated ourselves. And then in 1989, 90, and 91, we set up these community areas where people came very freely. And if you look at a chart to see how HIV has been reduced since educating ourselves, approaching the market, remember, no market, no sale, approaching the market as to what you got to do. You got to have responsibilities for yourself to protect yourself. It started to work, and now it's a huge difference between where we were in 1990 and where we are now. In 1990, I became the mayor of the city of Paterson, New Jersey. I was elected. I got a call 2 weeks after I was in office, and the Fed said to me, we have no one to help us oversee the money that's going to go to your county, Passaic County, small county, and Bergen County, one of the biggest in the state of New Jersey. Would you take the job? It doesn't pay anything, but we need somebody right now. We've come a long way from that, and we're not afraid to talk about it, and we're not afraid to look to the individual to help him. This is not a charity case. This is protecting the entire community. We have an epidemic of opiates, and we think that the Postal Service got to be part of our attack in trying to prevent it from even getting into this country. So I support this 100%.
I thank the gentleman. Mr. Chairman, I yield back.
Thank you very much. Gentleman from Massachusetts.
Yeah, you're probably aware of this. The National Association of Letter Carriers, the National Postal Mail Handlers Union, the American Postal Workers, and the National Rural Letter Carriers Association are opposed to the bill. I'm just curious, did you guys call them in, or the Postal Service? I mean, I'm seeing that there was no hearing on the bill. Did you consult with them?
We've had the staff, we talked to the postal services. I'm a strong advocate of the USPS, but darn it, this is an epidemic. We changed this legislation from the very beginning, my friend from Massachusetts, to try to comply with some of the problems that existed. We think we have.
All right.
We think we have.
Okay, well,
I'm aware of the letter.
Yeah, okay.
I got it right here.
Yeah, and I asked unanimous consent to insert in the record, but I have no further questions.
Enter that into the record, please. Gentleman yields back his time. Gentleman yields back his time. Thank you very much. The distinguished gentleman, the member of the Rules Committee, but also the subcommittee chairman for Energy and Commerce and Health, the gentleman, Dr. Michael Burgess, recognized.
Mr. Chairman, you've already heard from me on this issue. I support what we're doing here and yield back my time.
Gentleman yields back his time. Thank you very much. The distinguished gentleman from Florida does not seek time. The distinguished gentleman from Colorado. Gentleman does not seek time. The distinguished gentleman from Freedom, Colorado, Mr. Buck, does not seek time. The gentlewoman from California, the distinguished gentlewoman from the great state of Wyoming, does not seek time. We are doing okay. You know, it's amazing. Successful rain dance has a lot to do with timing. Gentlemen, I will tell you that there is no easy answer to a big problem. What I do suggest to you is that all four of you seeing this issue as a result of an investigation, as a result of hard work, as a result of working, comes as a result of a team that intends to work together. Mr. Chairman, I want to thank you. I want to thank you for taking on the issue that you know is a little bit difficult, but that you know must be understood and us working on. So I want to thank each of you for being here today. If you please make sure that whatever you brought in writing is available to our awesome stenographer. And I want to especially thank Angela, who I have not seen for some period of time. Your distinguished staff member, perhaps your staff director, I'm not sure right now, but Angela is a person who I've worked with for 20 years and gives a great products. Mr. Chairman, thank you to your staff for the work that they do also.
They're terrific. Thanks,
Yes,
Chairman.
sir. We also acknowledge that I was late coming here because the Honorable Sam Johnson had his portrait that was unveiled today at a ceremony that you were officiating. I want to thank you very much on behalf of the Texans for your attention to that detail.
Thank you, Chairman. He's a hero.
Yes, sir. Thank you very much, gentlemen.
Thank you.
Is there any other member that would seek time? H.R. 5788, Securing the International Mail Against Opioids Act of 2018. Seeing none, this now closes the hearing portion of the day, and I want to thank the members for their attention. I'd also like to thank, as we prepare ourselves for interns from my office that I know that were here, Kaylee Young, a rising junior at Texas A&M, majoring in finance with a minor in economics from Dallas, Texas. Anders Starud, rising senior from St. Andrews in Scotland, majoring in Arabic and Middle East studies from Norway. Damian Doolittle, rising senior from Campbell University, majoring in Homeland Security from Goodview, Virginia. Cale Cherry, a rising senior at Baylor University, Waco, Texas, majoring in economics, who is from Dallas, Texas. Brad Clendenning, rising junior at Southern Methodist University, majoring in political science from Dallas, Texas. And two members of the Rules Committee College Intern Program, Kaylee McGaffney, rising third-year law student at Chapman University from Newport Beach, California, who is sitting right behind me. And Sean Goldstein, rising third-year law student at Florida State College of Law, Fort Lauderdale, Florida judge, who is here at the Rules Committee. Sean, thank you very much. I appreciate them being here, coming to see this committee and its work, and we would now be in receipt of a motion from the distinguished gentleman from Georgia.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee report a structured rule for consideration of H.R. 2851, the Stop the Importation and Trafficking of Synthetic Analogs Act of 2017. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for purposes of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-74 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in Part A of the Rules Committee report. Each such amendment may only be offered in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 5735, the Transitional Housing for Recovery in Viable Environments Demonstration Program Act, under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule makes in order as original text for the purpose of amendment and an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-73 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 3 of the rule provides for consideration of H.R. 5788, the Securing the International Mail Against Opioids Act of 2018, under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Ways and Means. The rule waives all points of order against consideration of the bill. The rule provides that the amendment printed in Part C of Rules Committee report, modified by the amendment printed in Part D of the report, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
You've now heard the motion from the distinguished gentleman from Georgia. I'll yield myself for 1 minute to explain this rule. We have one rule, 3 bills, H.R. 2851, which will be the SISTA, which, as we know, was discussed first. Structured rule, 1 hour debate to judiciary. Make an order for amendments, 1 Republican, 2 Democrats, 1 bipartisan. Motion to recommit, H.R. 5735. Structured rule, 1 hour debate to financial services. Mr. Barr makes an order of 4 amendments, 3 Republicans, 1 Democrats. Motion to recommit, H.R. 5788. Known as the STOP Act, came from Ways and Means. Closed rule, 1 hour debate. Ways and Means provides for adoption of Bishop 1, amended by Bishop number 2. Motion to recommit. And we are attempting to move forward that on a bipartisan basis. I thank you for listening to this. Is there amendment or discussion to that? Yes. Gentleman from Colorado.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 2851 by Representatives Pocan, Gosar, and myself, number 10, which would prevent the Secretary from placing a natural botanical substance under new scheduling authority and will require Secretary use existing scheduling procedures under the Controlled Substances Act if supported by existing medical and scientific information. If I may, Mr. Chairman, the Pocan-Gosar-Polis amendment, a bipartisan amendment which I think would improve the bill, would prevent a natural botanical substance from known as kratom, which is a cousin of the coffee plant that's frankly used by many to battle opioid addiction. I've heard from many constituents about how kratom has been critical to their sobriety as they battle opioid addiction. You know, and we're debating these bills today because we know that we need to take action to address opioids. But instead of trying to ban substances that are not among mainstream treatments, we should explore alternative therapies and treatments that work for people like kratom. Simply put, we need to improve access to alternative options like kratom because patients need and deserve options that are less harmful than opioids. This amendment would serve to prevent the scheduling of kratom under the new classification, something that, if it enacted, would be devastating to so many Americans who use kratom for pain management or to recover their sobriety and escape from opioid addiction. I urge the committee make this amendment in order and urge my colleagues on both sides of the aisle to join Representatives Gosar, Pocan, and I to pass this amendment.
Thank you very much. Discussion?
Very briefly, Mr. Chairman.
Gentleman's recognized.
I support the amendment, and I only point out, Mr. Chairman, that of all of the measures that we are dealing with, I think my office received more calls in support of what Mr. Polis has just presented. So I support the amendment, Mr. Chairman.
Thank you very much. I've got a question. Was this presented at the time that they went through markup at all? hearings, anything that would?
I don't know if Mr. Gosar or Pocan, and I'm certainly not on the committee, so I don't know if anybody was on the committee of jurisdiction to do that. I simply don't know whether it was offered. We have talked about Kratom before in this committee. I've offered similar amendments, I believe, as part of appropriations bills. I'd have to go check. We've brought this to this committee's attention before. And I would certainly encourage the committees of jurisdiction to hold hearings going forward on this. In the absence of that record and the hearings, I think it's very important to err on the side of patient access to Kratom, which is why Mr. Gosar, Pocan, and I are bringing forth this amendment today.
Thank you very much. I have not seen any testimony on this effort, but I do recognize the bills before us. Further discussion? Vote now be on the post amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No.
Roll call, please.
Gentleman asked for roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Newhouse. Mr. Newhouse, no. Mr. Buck. Ms. Cheney. Ms. Cheney, no. Mr. McGovern. Aye. Mr. McGovern, aye. Mr. Hastings. Aye. Mr. Hastings, aye. Mr. Polis.
Aye.
Mr. Polis, aye. Mrs. Torres. Aye. Mrs. Torres, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
Excuse me. 4 yeas, 6 nays.
The amendment's not agreed to. The gentleman's doing just fine. Not agreed to. Further amendment or discussion. Gentleman from Colorado.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for amendment number 7 to H.R. 2851 by myself and Mr. Correa, which would simply require the VA to study medical marijuana as an alternative treatment for prescription drugs. This amendment is very similar to the VA Medicinal Cannabis Research Act, which I would point out passed unanimously out of the Veteran Affairs Committee with the support of both Chairman Rowe and Ranking Member Waltz. It's simply common sense that we need to find the data to get the VA started down being able to prescribe medical marijuana as treatment for veterans, often as an alternative to more harmful and more addictive opioids. In states like Colorado, we're already seeing the benefits of medical marijuana, suffering from a wide variety of problems, including pain management. It's also personal for me. Last year, I was able to present a Purple Heart to a veteran who lives in Colorado, and he put his life on the line for our country. He told me that he uses medical marijuana for his pain issues and was able to get off of the opioids that the VA had prescribed because of medical marijuana. His girlfriend testified that he's much better for it than he was on the prescription opioids. And, these kinds of stories are happening across the country, but unfortunately they're forced to happen outside of the VA at personal cost to the veterans who have served, who are denied the most effective and least harmful medicine at the Veterans Administration. A Reuters story from 2017 reported that veterans are twice as likely as non-veterans to die from accidental overdoses of opioids. And I think it's important that we make sure that veterans are able to take advantage of the potential benefits of medical marijuana through the VA system. And Mr. Chair, this amendment is simply a study. I have wanted to move forward, as I indicated, with access, but I think the very least we can do in this bill to battle opioid abuse is to investigate how the effectiveness of medical marijuana as an alternative option to prescription opioids. And if this amendment is made in order, I'm sure it will receive a strong, if not unanimous, show of support, as it did when Representatives Rowe, Waltz, and Correa steered it through the VA committee unopposed. And I think it's important that we at least take this step to combat opioids by providing information about alternatives that are less harmful, less addictive, and can still be effective in many cases. I have an article for the record I'd like to submit, Mr. Chairman, from Reuters that I cited earlier.
Without objection.
And I urge my colleagues on both sides of the aisle to adopt this amendment and move forward with the study.
Thank you very much. Further discussion? The gentleman would recognize that this bill that we're talking about, H.R. 2851, is being added to the Stop the Importation, Drug Trafficking of Synthetic Analogs Act of 2017 that essentially deals with the United States Postal Service, not the VA, so thus it was not germane to the bill. Yes,
Mr. Chairman, yeah, no, and I appreciate that, but we're the Rules Committee, we could take care of that.
Good.
But I would just point out, you know, the gentleman's previous amendment was germane. And so, I mean, I'm not quite sure what we need to do to be able to get something in order here, but he did have a germane amendment, and it was rejected along party line, and it's kind of unfortunate as well, because he's also on this committee, and I think he deserves the benefit of the doubt. But in any event, we can make this in order, and I thank the chairman. I yield back.
Yes, sir. Yes, sir.
And my motion did include making the necessary waivers, to be clear. And this, again, has unanimous support of the chair and ranking member on the appropriate committee. And this is an appropriate vehicle for this largely non-controversial measure to move forward and have a chance of becoming law.
I'd like to ask the gentleman a question. I'm not trying to challenge you at all. So Chairman Rowe said on this bill, this is what he supported?
No, as a standalone measure, they supported it, and we're legislators, and we always look for vehicles to move things, and this is an effective piece of legislation that the chair and ranking member of the Veterans Committee support, that if my motion to grant the necessary waivers is granted, can simply be added to the bill.
Yes, sir. Well, I have spoken to the chairman of the committee a number of times about the VA's view on these bills, and I think study is one thing that they are undertaking, as you suggest, in that committee, with some very specific observations of where that study might take place, et cetera. And so I'm going to let Mr. Rowe approach us when he's ready for that. You're entitled to do what you're doing. I appreciate the gentleman for the discussion. Seeing none, the vote now be on the opposed amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No.
Roll
Those
call,
have it.
please.
Those have it. Gentleman asks for roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mr. Collins. Mr. Collins, no. Mr. Byrne. Mr. Newhouse. Mr. Newhouse, no. Mr. Buck. Mr. Buck, no. Ms. Cheney. Ms. Cheney, no. Mr. McGovern. Mr. McGovern, aye. Mr. Hastings. Mr. Hastings, aye. Mr. Polis. Mr. Polis, aye. Mrs. Torres. Mrs. Torres, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report.
4 yeas, 7 nays.
The amendment is not agreed to. Further amendment or discussion? Seeing none, the vote now be on the motion from the distinguished gentleman from Georgia. Those in favor signify by saying aye. Those opposed, no. No. Ayes have it. Ayes have it. Gentleman asks for roll call vote. Clerk will poll the committee.
Mr. Cole, Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Newhouse. Mr. Newhouse, aye. Mr. Buck. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mrs. Torres. Mrs. Torres, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 4 nays.
The motion is agreed to. Accordingly, the gentleman from Freedom, Colorado, the distinguished gentleman, Mr. Buck, will be handling this for Republicans.
The gentleman from Colorado, Mr. Polis, will be handling
Mr. Polis will be handling this for Democrats. I want to thank each of us. Judge, you normally have a question for us at the end of a committee hearing. Does gentleman seek time? Sir, we do not have any other meetings scheduled for the week. I want to thank you for your question. Thank you very much. I appreciate the staff for their work this week. We have now completed our work for the day. Those go down to the record. We're going to support whoever's filing the